Good morning, everyone. Welcome back. And I just want to provide a wee update before we get started today. And this is also for anybody who's following the proceedings online as well. Unfortunately, Professor Stiles is unavailable to give evidence today and will not be available for the next few days either. So we've decided to move things around a little bit, and we're going to take Mr. Thompson's evidence this morning, and then we will finish for today. And we will commence the Ministry of Defence evidence tomorrow. And the plan is that we will get through the Ministry of Defence's evidence through the entire day tomorrow, and the inquiry will not be sitting on Friday. But Friday is there as a backstop, just in case. So if we don't happen to get through everything on Thursday and we feel it's too much to try and squeeze everything in, we can potentially use Friday. The plan is to finish up tomorrow. Okay, so that's just for want of an update. Mr. Hardy, would you like to carry on with your next witness, please?
Thank you very much. Then this is the evidence of Mr. Rhys Thompson. In addition to the documents that were set out on the list yesterday, we're also going to need the onshore wind policy statement. And I suspect that Chapter 6, onshore wind and aviation considerations, will be familiar to most people. So by way of introduction, then you are, I'll give you a full name, Dapper Rhys Thompson, and you are a commercial director at Community Wind Power Limited, which is a sister company of the applicant. Prior to that, you worked for the Cooperative Bank. You tell us that you lead the commercial team at CWL, and as the commercial director responsible for a range of commercial activities across the business. So that includes legal, macroeconomic and policy matters, complex planning objections, due diligence, corporate finance, extensive experience in negotiating, drafting and implementing technical commercial agreements, including those associated with planning matters. Previously negotiated and agreed contracts with the Ministry of Defence associated with discharge for Section 36 conditions arising from MOD aviation objections. Also tell us you've acted as witness at planning inquiries in relation to applications under Section 36, given evidence in other legal proceedings associated with wind farm development. Is that all correct?
Yeah, that's all correct.
And then this, perhaps importantly, to add to that, you tell us you're not a technical expert. The technical research and evidence submitted in relation to the subject matter of the Eskdale seismic array inquiry session is being carried out by independent experts appointed by the applicant, who've each submitted separate inquiry reports. So you're not speaking to technical matters where the applicant relies on the evidence of those expert witnesses. We are going to look at some of the points you raise in your various documents, but before we do that, I just want to pick up on some supplementary points and start really with the appointment of experts and why you went to the individuals that the company did. So can you explain why those sitting on this side of the room are here?
Okay, so taking them in order of evidence, we appointed Professor Tuckwell of RSK because RSK are a leading environmental consultancy. Professor Tuckwell is the head of the Geosciences Division and has been responsible for geotechnical matters on a number of UK's largest infrastructure projects, including HS2 and nuclear power stations. We appointed Professor Macbeth because he was the author of the original papers which were used to define the values that we were investigating in the algorithm, and we appointed Professor Stiles because of his extensive background and knowledge of the Eskdale array and the implementation of the original algorithm.
You know, in terms of the research and the work that's been done, presumably the client had a free range of those consultants it might go to. So in terms of what you understand, the view that you would take, or your assessment as commercial director, in terms of their authoritativeness or not?
That's it. So we selected them because of the gravitas that we believe they have in the specific fields of expertise.
Now, you've read all the papers, you've been involved in this case now for a number of years. What is your view now, given where you are in the process?
I'm sorry, Madam Reporter, I do object to that question. It's a matter for the reporter what weight and reliability she feels should accord to the various expert witnesses, and I'm not sure if a lay witness can really assist you, Madam Reporter, in assessing that matter.
Well, yes, I think it's a perfectly fair question for a lay witness. Obviously, I don't want to assist you, but it's your view in relation, having seen all of the evidence, whether or not you've changed your position.
So obviously we rely on the evidence of the technical experts that we employ. My own personal view, having seen the evidence, particularly the evidence of Professor Tuckwell in relation to background noise measured at the array, is that there is significant capacity for further wind farm development in the region, and the conclusions that I draw from reading the Heriot Watt report are that further work would provide a data set so significant and so robust that the value of Q and V could be put beyond reasonable doubt.
And we'll come back to the scope of works in a little while. So the second point I want to raise comes out of the evidence of Professor Stiles, always one of the issues that Professor Stiles dealt with, and that's utilisation. So the science part of that, I'm going to leave. We've got the written reports, and the MOD can make comments on that as they think fit. But I'm interested in your evidence as a wind farm operator in relation to utilisation factor. Perhaps you can explain to the reporter what you understand by that term, but then give your evidence about what that means.
So the utilisation factor, it's described in the original Stiles 2005 report, was a proportion of the time by which wind farms could exceed the noise budget, and that was defined as 20% of the time that the noise budget could be exceeded. The way that utilisation factor is currently used in the Xi algorithm is an application for a factor of 1, so 100%. And that means that the algorithm assumes that all wind farms are operating at 100% capacity all of the time. Obviously, as a wind farm operator, we run 8 wind farms. We run some very productive wind farms, but the nature of wind is an intermittent energy source, so it doesn't operate 100% of the time. I think it's probably well known, and so the application of a utilisation factor of 100% is not reflective of the operation of an onshore wind farm.
Thank you very much. The third point then relates to the scope of works, and I just want to understand what the input of the of CWL has been to that, and your understanding of what's required, and indeed whether or not that is fixed in stone.
So obviously we employed the technical experts to define the scope of works. We're not technical experts ourselves. So that was compiled by Professors Tuckwell, Macbeth and Stiles. Obviously we would be the party that appoints the work. It's likely that RSK, which has obviously quite significant resources, a business would undertake the works on our behalf in conjunction with the oversight from the 3 professors, and the expectation is that the results from that scope of works would be published, would be provided to the working group, the Ministry of Defence, and my sincere hope that we could work constructively with the MOD to implement the scope of work.
So a couple of points to follow on from there. You mentioned that the research would be made available. Is that the intention?
It is, yeah. Obviously, it's provided, it's undertaken and delivered in the context of a statutory process, and notwithstanding that, it would be provided separately to the working group.
Thank you very much. Lest there is any concern, I'm not going to go into what's happened to Professor Stiles, but if he was unable, I'm not saying he is, but if he was unable to take any further part in the procedure, how would the elements that he was going to cover be dealt with?
Obviously, we're very much hoping that Professor Stiles will be able to play a significant role in the scope of works, but If he is, for whatever reason, unable to, then there is, as I mentioned, significant resource within RSK. It's a major international consultancy. They have all the technical expertise and the manpower and the equipment to undertake the full scope of works. So no concerns that the inability of Professor Styles to participate with prejudice that's going to be.
In terms of the length of time and the scale of effort, you heard some evidence yesterday from Professor Macbeth. He said it might be about 4 weeks or so in relation to gaining data. Do you have an understanding from your discussions with the experts on this side about how long it would take to get meaningful output from scope of works?
Obviously, we heard from Professor Macbeth yesterday that it could be not more than 4 weeks. We've assumed conservatively that it could take anywhere up to 12 months to collect the data set. Obviously, the objective here is to compile a very significant data set with which to take the calculation of the value of Q and V beyond the remit of professional assessment and into the realms of data science. So it becomes a product of the data set, and therefore if it took a full year to collect a very extensive data set, then that would be, in my opinion, worthwhile.
Thank you. Now let's get to the sort of heart of it after those supplementary questions, and I'm going to just, if you want to go to it, it's the precognition of Mr. Egan, but I'm just going to read something to you if you haven't got it. It's paragraph 7.6 and 7.7 of his precognition. I don't know if you've got that. Main precognition, yeah. It's in a number of places, but I'm going to take it from here. And it's internal page 9, paragraph 7.6. Do you have that? Yep. So the MOD accepts that the current Estelle-Muir SGB predictive model used to calculate Estelle-Muir threshold impacts requires to be assessed. However, the EWG is the proper forum for consideration of this issue in the public interest. And then over the page, on page 10, from the MOD's point of view, the current Estelle-Muir SGB predictive model safeguards the array effectively, albeit that the built-in safety factor, which was conservative by design in 2014, results in overestimation of output. And as Mr. Laws has explained, the MOD doesn't consider it appropriate that such complex and technical scientific matters put into focus within the public inquiry process, such as has occurred in this instance. So, starting point is that there's an over prediction, needs to be changed, and science will be very helpful. That's all appears to be common ground. But what the MOD is saying is, well, look, the EWG is the proper forum for determining that issue. So I want you just to give your some evidence, please, on the EWG and the relationship that your firm has had with that to start with.
Okay, well, the EWG has had many guises over the almost 20 years that it's existed on and off. Our experience with the Estelle-Muir working group was that it was predominantly a cohort of competing developers, obviously all of whom have their vested interests. It didn't, in my opinion, produce a constructive forum for discussion of matters such as this. And my view is, as I think I set out in my recognitions, that in a statutory process there is a proper procedure for progressing matters such as this, and that is a bilateral basis between the applicant and the consultee in the normal fashion, with, as is the case with other panel objections.
So in terms of the appropriateness, moving the question on, of dealing or bringing these matters before the ministers in this sort of forum. What's your response to that, rather than the EWG?
So, I mean, my view is that the matter should be brought before the ministers in within the existing framework of the Section 36 application procedure. I would note that the reformed structure of the SDLMUR working group and membership doesn't actually include any developers anymore. So I see a gap in the application process whereby you have an objection to an application which you're unable to address directly with the relevant statutory consultee if the working group is to be the correct, if the working group is taken to be the correct mechanism by which matters pertaining to the SDLMUR array are addressed.
Let's turn then to the policy statement itself. You deal with this in paragraph 3.5 of your supplementary report, and there's a reference to ongoing technical research. So background to SDLMUR is at section 7.2, that's internal page 42. And so in your paragraph 3.5, you refer to that ongoing research and the references to work undertaken by Xi Engineering. That's described, I think, in the SOAM to reassess the source term. Do you want to just explain your evidence on that?
I mean, the work to reassess the source term is valuable work. It is work that can be undertaken in parallel with work to reassess the propagation term. I fully support the acquisition of data to refine the values for the source term. It seems to me, not as a scientist, but it seems a logical and data-driven process. And I think there are many similarities between the approach proposed in the scope of work relating to refinement of the source term and the scope of work proposed by the applicant relating to refinement of the propagation term.
In terms of the work then that's going to be done, you make a point that in your view the Scottish Government's emphasis is rightly on data collection and an evidence-based approach to safeguarding. And for what your understanding is, you've seen the evidence and you've heard the experts, what do you make of that?
Obviously, as we've set out, and I think it's been quite consistently set out by the technical experts, is that this is, it is a scientific and data-driven matter. So our view is that the acquisition of more data rather than taking a view on a number is the correct approach to take to safeguarding of the array. Obviously, the values used for propagation term are taken from scientific assessment undertaken 30 years ago, and it seems logical to me to acquire a data set to secure a site-specific parameter for that very important aspect of the algorithm.
So just with our finger in both the policy statement and your work, so 7.2.7 of the policy statement, so unlocking potential capacity will require decisive and meaningful action from the Scottish Government, UK Government, MOD. To do so, we must recognise safeguarding of the array lies within the MOD policy remit, maximisation of renewable energy deployment lies within the Scottish Government policy remit. So you've got those balances. Paragraph 3.8, you make of your you make a point that, look, there's no safeguarding argument for continuing to operate an algorithm using disproven scientific values, as you state. So given what I read out to you from Mr. Egan's work, so the MOD accepting that the current SDMUR SGV predictive model used to calculate SDMUR threshold impact requires to be reassessed. So not maybe reassessed, but requires to be reassessed. What's your view on that?
I think it's been highlighted on a number of occasions previously by Dr. Bowers that work to reassess the propagation term should be undertaken. So I think he mentions it in CD 1412, paragraph 914, and he also references it in APP 0123 on page 4. So this isn't work that has been, or proposal that has been considered without reference to indications that the MOD have previously given as to where further refinement of the safeguarding algorithm could occur.
Okay. 3.9 overview recognition. We have a couple of documents to open up. So this is the scope of work shared in draft by the Scottish Government provided to the SDMUR working groups. That's CD 14.078. And then there's also the objectives in the EWG draft terms of reference, or the TORs 14.079. So with those two documents in mind, what is your position in relation to what was put forward there?
Just a moment.
You do with this in your 3.9 and 3.10 of your supplementary inquiry report.
So considering CD 14078 first.
Yep.
I think that approach sits quite comfortably with the approach we're taking. My own personal view is that the scope of work that we're proposing is of an equivalent, if possibly not more comprehensive basis than the scope of work proposed there, albeit that they consider different aspects of the algorithm, so they're not mutually exclusive.
Okay, and in relation to the draft terms of reference, 14079, is there anything you want to add?
I think, just reinforce what I mentioned earlier in relation to the sitting of an applicant within the working group. So it's notable there that the membership no longer includes an applicant who has a standing MOD objection in relation to the SWRA, and it seems to me that as a statutory process that cannot be correct, where you have no means by which to address an objection to your application if the working group is the only means of considering further refinement of the safeguarding of the array.
Okay, thank you. So what the applicant proposes is a suspensive condition. So we've got an agreed position that something needs to be done. We've got plus outputs and all of that. But what we're now told, the MOD is concerned about risk, and clearly safeguarding of the array is an important matter. So let's turn to the suspensive condition. You deal with this in paragraph 4.4 of your supplementary inquiry reports, elsewhere as well. But I want to start with a high-level point about allocation of risk with a suspensive condition. So what is the risk in terms of fulfilment of the conditions that are set out in it?
So obviously I'm not a lawyer, but my view, having overseen the discharge of suspensive conditions pertaining to MOD objections with regard to radar, is that until a turbine is erected, there is no risk, whether that be to a radar installation or, in this case, to the SDMUR seismic array. The risk arises when a turbine is erected and, in this case, begins to produce and propagate seismic noise. until the first turbine is erected, I don't see any risk to safeguarding of the array.
So, in terms of burden of discharge, where does the burden lie?
Well, obviously, the proposal on behalf of the applicant is for a suspensive condition. No turbine may be erected until the scope of works has been designed, implemented, and submitted for the approval of the authority. The risk obviously lies with the applicant in terms of cost and work, with the overarching position being that if the applicant cannot demonstrate that the conclusions of the Heriot-Watt report are reinforced by the expanded data set, then the wind farm cannot be constructed. That's the applicant's risk.
Yeah, so you've got three stages. They're set out in 4.5.1, 4.5.2, 4.5.3 of your supplementary report. And so submission written approval of the scheme, and then prior to seeking discharge of the suspensive element, applicant must submit a report of the results of the approved scheme to the planning authorities and the MOD, and then you can't build a turbine unless the planning authorities have confirmed in writing their satisfaction that the proposed development wouldn't result in the exceedance of the thresholds. Those are the three basic constituent elements. So in terms of risk, and the applicant not being able to discharge those, what sort of risk, and where does that lie?
Well, obviously the risk lies with the applicant because there is obviously a scope of works to be implemented and paid for. Obviously the applicant's view is that the conclusions of the Heriot-Watt report, reinforced by the work undertaken by RSK, gives us confidence that the condition will be discharged. But until the turbine is erected, then the risk lies entirely with the applicant.
So you deal with this in 4.12 of your supplementary report, and just to pick up on a point there about cost and who's going to pay for this. So the scope of works and the discharge of or potential discharge of the condition, who's going to pay for that?
Well, that'd be the applicant.
You tell us in 4.13 that a seven-figure sum has been spent to date on this. Now, of course, you're not. In a sense, that's a matter for the applicant, and nobody's going to say, well, just because you've spent some money on this, that you deserve your planning permission. But the level of commitment, explain to the reporter what that is, given that level of investment.
Obviously, there'd be a comparable sum, if not more, to be spent. That is the nature of business. The scope of works is comprehensive. It will cost. Obviously, the benefit will be to the consultation zone and the industry as a whole. Obviously, the values of Q and V that have been calculated to date release a significant amount of additional capacity within the consultation zone. So, obviously, it would enable the proposed development to be constructed, but it would also enable a great deal of further development within the consultation.
So why, in your view, is a permission with a suspensive condition of this sort attached appropriate?
Obviously, there's a significant opportunity cost to not undertaking further assessment into the propagation term. Obviously, as I mentioned previously, it's never been reconsidered throughout the tenure of the working group. It has been highlighted on a number of occasions as being suitable for reassessment, and that site-specific value should be calculated. And in the current energy crisis, the opportunity to deliver a significant amount of additional onshore wind within this region of southern Scotland should not be overlooked.
Paragraph 4.16, you deal with the point about what risk or cost may fall on the MOD, and you say in that paragraph the MOD bears no cost or risk in that process. So, are you asking the MOD to do anything during the suspensive conditions step?
Well, obviously, the proposal is that the MOD would be provided with the conclusions and the data set from the scope of works alongside the working group, albeit they're not part of the statutory process. As I mentioned previously, our hope is that the MOD would engage with the scope of works and would be a partner in that approach. But until, as I mentioned previously, until a turbine is erected, then I cannot see any possible risk being able.
There was a point that was dealt with yesterday, and perhaps crudely put as the sort of I'm all right, Jack position. Is it a case that this is just for foresight, or is the research that would be, or the results from the work that'll be undertaken, would that be made available to others, including other developers?
It would be made publicly available, obviously as part of the statutory process, and as we mentioned, it would, with revised values of Q and V as we consider them to be, would enable a significant amount of additional onshore wind capacity within the consultation zone. So it is very much not just for the benefit of the applicant, but for the industry as a whole.
And if that could be achieved, and you'd have to demonstrate that it could, to what extent does that fit with the one of the two themes in 7.27 of the onshore wind policy statement about maximisation?
This is obviously a significant portion of southern Scotland that's affected by this constraint. It is an area of southern Scotland with good access and good grid connection capabilities. It would very much, in my view, accord with the Scottish Government objection of maximising renewable energy development.
It's perhaps a crude term again, but bed blocking. So 4.18 of your supplementary report, you deal with this. Do you want to just explain why you don't think this would result in bed blocking, or perhaps explain to the report what bed blocking, what you mean by that, and then why you don't think it's a problem?
So bed blocking as a term is considered to be where a development that has been granted consent would prevent the progression of other developments which may have a contingency on the first application. My view is that this proposal wouldn't constitute bed blocking because, as we've heard from technical experts, the scope of works to be delivered is short-term in nature. So we're not talking about an extended protracted period of time. We're talking about less than 12 months for the data to be acquired and processed. And as a result of that, and in conjunction with the expectation of not wanting to forejudge the outcome of the data collection and processing, the expectation that the data will deliver significant additional renewable energy capacity means that there would be no further projects at the time that would be prevented from progressing their application.
Mm-hmm. In terms of the how complementary or otherwise this work that's being proposed would be with the work that's going to be carried out by Xi Engineering, just explain a little bit about that. Is this work in conflict in any way, or does it work alongside it?
Well, we heard from Professor Tutwell yesterday that the Estel-Muir algorithm works on the broad basis of the source pathway receptor model. So the work that Xi Engineering have completed previously and are undertaking at the present time is related to the source term of the algorithm. Whereas the work that we're proposing to do is an assessment, well, a corroboration of the revised value for the propagation term, which equates the pathway element of the model. So, in my view, I don't see any conflict between the two work streams. In fact, both mutually beneficial.
A point you make at the end of your paragraph 418 is you say, well, we don't know whether that work by Xi Engineering will be accepted and adopted by the MOD, but in any event, the work carried out in relation to measuring Q and V for the Estel-Muir area will allow not only the proposed development to be constructed, but the whole of the waiting list. So the picture you paint is one of, well, these things will be going on together, but if it's the work that's undertaken on behalf of this client that would allow that waiting list to come forward.
That's it. So obviously the work and the reassessment, refinement of the values for Q and V and the propagation term would deliver the projects on the waiting list. We've seen obviously from Professor Tuckwell that there's no measured increase in noise, and we see from references to Dr. Barrett's reports that the assessment of the propagation zone should be undertaken. I think the collection of that data set would have very significant benefits, not just for the applicant and onshore wind, but the policy ambitions of the Scottish Government.
Thank you very much. Just a couple of other points then in relation to suspensive conditions. One of the big points that the MOD makes, if I can put it like that, is look, there's a sort of ceding of control. At the moment it is charged with responsibility for safeguarding the array, and it's concerned that the responsibility for a debate about science gets passed to another decision maker, and in this case that's an inquiry. What's your response to that?
Obviously, we undertake the discharge of suspensive conditions with a number of statutory consultees. It is a very well-defined process, and what we're proposing here is no different to the process that we would undertake with suspensive conditions into other objections, aviation, radar, the like. So no different to the approach that we would take with any other suspensive condition pertaining to the objection of a statutory consultation.
In relation to the array and the approach that's been taken to imposition of suspensive conditions, your 420 and your supplementary report, you give a couple of examples. Now, they are subject to comment by the other side in later documents, but I want to just give your view on the usefulness of those as comparators in this instance.
Well, obviously, they have been applied as suspensive conditions. The 20 Shilling Hill suspensive condition has been discharged by the MOD. Obviously, it is commented on by Mr. Egan, but obviously it does provide, in my opinion, a precedent for this kind of work to be undertaken, delivered, and ultimately discharged. In the same way that it has been done for other MOD objections such as aviation, radar, and the like.
Another criticism made by the MOD is, well, look, you could end up with a patchwork of decisions, because if this is dealt with differently by different planning authorities and indeed different jurisdictions, so south of the border you've got English authorities as well. The suggestion being that this becomes unworkable and unwieldy. So you've seen that criticism. What's your response to that?
Obviously, each application is a statutory application which has to be assessed on its own merits. No doubt, without wanting to forejudge what those respective conditions might look like, or what words might be proposed by the respective applicants, it would be for the relevant authority to assess it at the time in the context of the framework, and no doubt with consultation with the MOD. So in my view, it's not the case that there would be a inconsistency or an inconsistency in approach, or a lack of joined up thinking with relation to the external array.
And in each case, with a suspensive condition that was imposed, where does the burden lie?
Well, the burden of proof lies with the applicant in every case, provided, and obviously we're talking about hypothetical future conditions here, but assuming that they've been drafted in the same context as the condition proposed by the applicant and were suspensive, then the array would be protected until condition is discharged.
Thank you very much. Now, you're not a lawyer, it may be a matter for submissions, but your understanding of the system, so far as the legal status of the MOD as a consultee is concerned, is there anything particular about it? Is it a super consultee or something of that sort?
Obviously, it's it is a significant consultee, but it has, in the context of statutory application process exactly the same way as all other consultees. Obviously, we point out that safeguarding of the SDL mural array is important. We're not proposing that that should be changed. We are simply proposing that the values for QMV that have been calculated should be supported by an additional data set to provide the comfort that the MOD need in order to change the parameters in the algorithm. And that is consistent with the approach that the MOD have taken not only to the algorithm to date, but also to refinement to the algorithm. It's a data-led process. We're just collecting data in relation to a new parameter that hasn't been assessed before.
And final point really is in relation to waiting list, and there's reference to litigation in the papers. What you tell us in your concluding section of this supplementary report 5.1.2, the proposed development has been properly allocated remaining noise budget and first place on the waiting list for headroom in the MOD noise budget that may become available in the future. So could you just explain that to the reporter a little bit, please?
Before you do, Mr. Thompson, this probably is more properly a matter for legal submission, and just to flag up that the MOD do not ascribe to this indication that there's any legal concept or legal rights arising from being allocated or put on a waiting list, as is clear from the Inner House's decision in the Energy Contour case to which Mr. Hardy has just alluded. So I'd just like to flag that up. It's not accepted that there is something colloquially described as a waiting list, far less that gives right to any legal rights or entitlement.
Well, that point's noted. Obviously, the MOD can make its submissions, in which case I want to ask the question even more. Your understanding then, please, Mr. Thompson, of the position.
Obviously, I'm not a lawyer, and perhaps it is also a matter for legal submissions. However, the noise budget is a finite resource. It will always be a finite resource. It's not an unlimited resource. Historically, there has been a waiting list of sorts. Even if there isn't whether there is no longer a structured waiting list, then there is a logical order of applications by wind farm developers, which you would assume is or would form the basis for the structure of a waiting list if one were to exist. And obviously Foresight has been, at the present time, allocated all of the existing noise budget, and as a result of that, you would assume has first call for any new budget. I would couch that with the fact that the assessments that have been undertaken by our technical experts indicate that not only is the proposed development able to be constructed with the revised values of QMV, but any projects on the supposed waiting list could also be constructed without prejudice in the array. So it is almost an academic concept in the context of the revised values of QMV as considered by the applicant.
Thank you very much. Right, that's all I want to ask you in chief. Normal thing, is there anything that you think I've missed or that you want to highlight further? Thank you very much. Will there be questions?
Yeah, thank you, Mr. Hardy. Ms. Crawford.
Thank you, Madam Reporter. Good morning, Mr. Thompson. Just to clear up a preliminary matter, the SDL Mural Working Group, you were taken in your recognition to the terms of reference CD 14079. And in relation to membership of that, you'll see that the last bulleted membership is the relevant industry body. Yeah. And I take it you are represented on that industry body or aware of it?
We are members of Scottish Renewables and Renewables UK, but those are industry bodies that represent a number of competing applicants.
Precisely. But the industry is represented on the SDL Mural Working Group through Scottish Renewables.
But an applicant with a standing objection, isn't it?
That's a working group rather than a place for competitors in the industry to have what's often described as a robust discussion. regarding their position and their commercial interests.
I guess as a forum for robust discussion, it is useful, but in the context of a statutory process, I don't see how it could have any application to a Section 36 proposal.
Well, we'll come on to discuss that, but the point I'm making so far as the working group is concerned, it might be very difficult indeed to arrive at consensus if there are a number of industry competitors, developers, who understandably have their own commercial interests and will wish to promote those, as regards the more general question of how best to release the opportunity for renewable energy in this particular area.
But there are two processes there, aren't there?
Well, I'm just looking at the working group just now. I'm not looking at the Section 36 procedure, just looking at what the terms of reference are for the working group.
So,
It's nothing to do with Section 36, is it?
no.
Okay, we can agree on that. You, on the working group, have a part to play through your industry-wide body as regards these terms of reference.
I think my point is that the industry bodies are representing a significant number of competing developers who will all make separate submissions on what the industry body should do, and therefore there is no avenue for an applicant who has an MOD objection to put its position across to that group.
Well, sorry, again we're talking across each other. I'm not suggesting that you as an applicant should be putting across your response to the MOD's objection in the context of the working group. I'm just asking you to agree with me. It's a fairly simple point that your relevant industry body is represented on the working group.
The Scottish Renewables and Renewable UK are on the working group.
Right, okay, we'll move on then. I don't think we're in dispute that the array is a very important resource.
No, the array is a very important resource.
And I don't think we're in dispute that the MOD requires to maintain its ability to detect nuclear test explosions.
The MOD requires to maintain its ability to comply with the CCDTA.
Which includes that the array is able to detect nuclear test explosions. And I don't think you really dispute that it would be reasonable for the MOD, having regard to those international obligations, to adopt a precautionary approach to maintaining the detection capabilities of the array.
No, but I think the word precautionary needs to be treated with care, because precautionary, in my view, does not mean refusal to countenance new science. I think that's alluded to. So obviously a precautionary approach has quite rightly been adopted from the outset, but that was subject to refinement in 2014 in relation to the source term following the acquisition of further data. And we're not proposing that the MOD stop taking a precautionary approach, but we are proposing that values used in the safeguarding algorithm have never been reassessed for site-specific terms.
Well, I'll come on to that, but the general proposition that it's reasonable for the MOD to adopt a precautionary approach, you don't take issue with that.
Well,
where you do take issue, and might continue, is where that precautionary approach sits in a scale, I suppose.
No, I think the issue I have is that precautionary approach is not to be some sort of ability to refuse to engage with revised science.
Well, I would agree with you there, and lest you be under any doubt, the MOD is not blind to looking at revised science. But we'll come on to look at that in a bit more detail later. You mentioned risk in your supplementary inquiry report and said that there was no risk to the MOD and no cost to the MOD. and you said that any risk was borne by you, and there would be no risk because if no turbines are erected, that's it, and no seismic ground vibration will therefore reach the array from your proposed development. But is the risk not this from the MOD? Namely that it has an algorithm which it has operated for many years now, which has served to protect the array. And you are proposing, as I understand it, that that algorithm should be effectively ignored by the ministers, and you're offering to suggest that you should be allowed to ignore that algorithm and go off and develop something else. Quite what that something else is not entirely clear.
No, I don't think that's what we're proposing in the scope of works. I think we could go...
No, if you just bear with me, I'll come on to the scope of works in a minute.
Well,
but just staying on the question of risk, please. You think risk is controlled because if your work leads you to the conclusion that the development can be safely built, then that's fine. If the work reveals that the development can't be built, well, again, game over. But there's another aspect to this risk, because if you're suggesting, and I just ask you to consider this for a moment, if you're suggesting to the reporter that she should make recommendations to the ministers that the algorithm can be ignored, and we can look at the scope of works and whatever may result from that, what's to happen with other developments, proposed developments? What method are subsequent decision makers to apply in looking to those other developments in relation to protection of the array? Are you suggesting that whatever results from your scope of works is to be used as a new methodology for all other applications? Or are you suggesting that's just for us, other developers will use the MOD's methodology, the algorithm, or indeed their own methodology?
Well, I think there's quite a lot to discuss there. I think if we just turn to the proposed scope of work, then we can see that at 3.2, what we're proposing to do is not to reinvent the wheel. We are proposing to simply incorporate the revised values for Q and V as corroborated by the new data set within the existing algorithm.
Stop there if we may. Indeed.
I think what I wanted to say was we're not proposing to reinvent the wheel. We are proposing to accommodate the revised values for Q and V within the existing framework.
Have you finished? So just taking that answer, are you then suggesting to the reporter, albeit we've not seen what this revised framework may look like, that once you've done the work, there will be a new algorithm, albeit it'll have different values plugged into it? And are you suggesting that's what the MOD should use, horrible phrase, going forward?
I'm really sorry, that's not... I said that we would use the revised value for Q and V within the existing framework. There won't be a new framework.
Well, it would be a new methodology.
No.
Sorry, not new methodology, it would be new values.
Within the existing calculation framework, it's just the same calculation algorithm, but with two new values in it.
And who is to approve that algorithm? Because we know it was developed on behalf of the MOD and they've used it. If they don't agree with those new values?
I think this goes back to the statutory process point. I really hope that the MOD would engage constructively with the revised scope of work, because it would be, in my view, beneficial for the industry and the country.
Well, that's your view. I just want to try and tease out exactly what it is you're proposing. Forgive me, I'm probably being stupid, but it's not deliberate on my part.
The proposal is to undertake the scope of works as proposed, to recalculate values for Q and V, and then to incorporate those revised values for Q and V into the safeguarding algorithm, which is broadly set out in 323 of the scope of works. Now, obviously, that algorithm is a mathematical equation that would be submitted within the context of the statutory framework, and in consultation with the MOD, that would go through the normal discharge condition process.
We'll come on to discuss how this is going to actually operate, well, practically, so far as the MOD is concerned. But before I come on to look at the scope of works, there is another point I would like to ask you to consider, if I may, and that relates to MPF4, and that's CD 08.012. And if I could direct you, once you've had time to find it, to Policy 11 on page 54.
Energy, yeah.
Oh, CB10, sorry. It was 8, that's my reading. Thought the reading glasses would improve matters, they don't. So it's Policy 11, if we have it on the left-hand column. Development proposals for all forms of, sorry, it's not that one, will be supported. It's further down the page, and on the next column, sorry. I don't read this out properly. Yes, little e on the right-hand column. In addition, project design and mitigation will demonstrate how the following impacts are addressed. And then if we go to Roman numeral 4, impacts on aviation and defence interests, including seismological recording. Now, just pausing there, your company has not come to this inquiry to demonstrate how the impact of phosphide on the array is addressed.
Well, I think what we are proposing is that the mitigation to demonstrate that the impact will be addressed, but the condition provides the mitigation to demonstrate how the impact on the seismological array will be addressed.
Well,
I think
at best, sorry.
So I think we do that. I think we do satisfy E4.
Okay. It would no doubt be a matter for legal submission. Is it not the case that you're proposing to carry out certain works, the precise nature is not entirely clear, and then present those findings to the planning authority rather than to this inquiry?
Yeah.
Yes, okay. And the proposed scope of works, and I will come on to look at this in more detail, does not set out how the effects on the array are to be assessed.
Well, I think it does.
Okay. And the methods to be used to assess those effects are not specified.
I think they are.
There is no measure against which to assess the acceptability of those effects.
I think that the measure is included as the reconstruction of the algorithm with a revised value. That's the measure.
And there's no indication of what account is to be taken of existing built or consented wind farms, or indeed of those which are still to be consented, or those for which consent may be sought after this inquiry concludes.
I think that's the product of the revised algorithm with the revised value. I mean, my view is that that is all captured by the scope of work.
All right.
Bear with me just one moment. So if we go to 3.3 of the scope of works, 3.3.1, we just read through 3.3. So recalculation of noise budget table parameters for each wind farm, either operating consented or in scoping planning, shall thereafter be input in their current order into the revised algorithm as amended in section 3.2 above. The updated outputs for each wind farm should be tabulated in the aggregate compared to the SWMUR noise budget. It should be determined whether Forside Wind Farm and any subsequent projects on the waiting list can be accommodated without breaching the SWMUR noise budget. So in my view, that section sets out quite clearly the points that you just made.
Okay. At present, as we know, the effects on the array are assessed against the current algorithm, which has been developed and, as we know, refined over the years, taking into account relevant science and research. Are you inviting the reporter to recommend another approach to assess the effects?
I feel like I've answered that question in a different context. We're not proposing a different approach. We're not proposing a new algorithm. We're not proposing to reinvent the wheel. We're just proposing to introduce refined values that are already included within the existing algorithm. So it's not a new approach. It's not. There's no change to the algorithm in its fundamental structure. It's the same algorithm, just with two new values.
So far as the source term is concerned, we know that Zaya doing certain work in relation to that. You'll recall hearing evidence yesterday that if you revise the propagation term, that has a concomitant effect on the source term. So the two do require to be looked at in tandem.
Only to the extent that when you introduce new, we're straying a little bit into science here. I'm not a physicist, but the source term includes the use of values for Q and V in its calculation. So when you introduce new values for Q and V into the propagation term, you introduce them to the source term at the same time, and then when you hit go on the macro for the algorithm, it will all be.
Well, again, the reporter may recall the evidence will be a matter for submission, but I don't think it's quite as simple as plugging in new values.
I think if we look at the actual, I'm not a physicist, so
Shall we just leave this
I'm
for
not
the
wanting
physicists?
to go back to GCSE maths, but if we look at the calculation in 323, the values for Q and V are expressly set out there, and the values for the source term are set out above, so you just reintroduce the new values into those two equations. Okay,
well, I think it's probably best to leave that one to the physicists. You will recall that we heard some evidence that it may not be quite as straightforward as that. So far as what's to happen with your scope of works and whatever output arises from that, you propose that once that output is available within whatever time frame that is, to present that to the planning authority.
Yeah, I think we'd be obviously the statutory process is to present it to the planning authority. We would also wish to present it to the working group. Obviously, it would go to the MOD, and it should go out for peer review. That's what should happen with science.
No doubt that's all admirable. That's not what your proposed suspensive condition says.
It says proposed provide to the planning authority, because that is the correct approach in terms of statutory process.
And the planning authority, as I understand it, having regard to your glossary of proposed conditions, would be the local authorities, in this case, Dumfries and Galloway and Borders Council. Is that correct?
That's what's in the proposed condition.
Yeah. So you're not proposing that this return to a reporter to consider, far less the ministers to decide?
Well, I think there's probably a number of points to address there. Obviously, the planning authorities are entitled and able to consult with whomever they wish as part of the discharging condition. As I've mentioned a couple of times, my sincere hope is that this could be developed and discharged in conjunction with the array with the MOD. But in the event that there was a disagreement, then the statutory process is for the discharge of the condition to be considered by the Scottish ministers and the DPA if the parties cannot agree. That is the approach for refusal or failure to discharge the condition, as I understand.
Well, what if the planning authority grants and discharges the condition, and yet the MOD is of the view that there isn't sufficient protection afforded to the array through the revised algorithm?
Well, I think we're getting into the bounds of legal submission there as to the proper procedure for failure or discharge of a condition. My expectation is that if the MOD truly believe that the condition should not be discharged, then there would be recourse either through the DPA or through the court.
Well, they wouldn't, no doubt, maybe able to make representations, but you'll be more familiar than I am. The normal statutory procedure as far as seeking consent, if parties disagree on, for example, scientific matters, they come to an inquiry, they hear evidence, the reporter makes recommendations, and the ministers decide that. If there are competing views about the validity either of methodology and or, I should say, results from that. Right. Yeah. Whereas with your proposed suspensive condition, if parties, and one hopes, of course, parties would work cooperatively and would reach consensus, they will no doubt continue to work cooperatively, but if they can't reach consensus, what is the procedure you envisage for having that considered and determined?
Well, my expectation is that if the parties can't reach consensus, then it would not be discharged by the local authority, and then there would be an inquiry held in the manner that you suggest.
Well, that probably is a matter for legal submission.
We would submit we would submit to the local authority in the context of either limbs 1 and limbs 2, and if the local authority determined that the condition should not be discharged, then the statutory process is for the Scottish ministers to consider submission in the inquiry context you just described.
All right. And just looking at your suspensive condition, we can see it's suggested the scope of works is to be, the scheme is to be based on the scope of works. As such, scheme may be amended with the approval of the planning authorities. What part do you see, if any, or role, if any, that the MOD should have in relation to any revisals to the scheme?
I think if the MOD were, we would welcome engagement with the MOD in respect to revisals. I think the meeting of experts held over the course of last year were helpful, but we would very much welcome revisions to the scope of works if the MOD thought it would be a benefit. Obviously, the involvement of the MOD is in relation to receipt of the results, which is referenced in the final sentence of WIN-1.
Yeah, I'm just looking at the earlier stage. I mean, so far as the scope of works and the ultimate scheme of works, what, in terms of the condition, is the role of the MOD in this?
Well, the scope of works is obviously before the inquiry in the context of the scope that we've just been through.
But it might be revised.
But it could be revised. I mean,
and what's the role of the MOD in that?
The expectation is that it won't need to be revised. It's comprehensive scope of works. I think our experts yesterday said that they were content with the scope of work. They thought it was robust.
But we might hear evidence from the MOD's witnesses they don't consider it to be robust. So what do you suggest would be their role in the event that the reporter thinks that might be correct?
Well, I'm in the event that a revision to the scope of works was proposed, following this inquiry, so in the context of limb 1 of the condition, then the applicant would apply to the local authority to revise the scope of work. The local authority would no doubt consult with the MOD.
Well, you say no doubt, but where do we see, this is a condition, you're required to comply with it. You may have a hope or expectation that local authority would consult. They may or may not. There's no requirement for them to do so in this proposed condition.
Okay.
Is there?
I mean, it's the involvement of the MOD in WIN-1 is respect to receipt of the results of the scope of work.
Correct.
That's
Yeah.
correct. Yeah.
And that's the end of their involvement. That's the start and end of their involvement in WIN-1. They're sent the results. And thereafter, let's look at WIN-2. No part of any turbine should be erected unless the planning authority have confirmed in writing that they are satisfied. And we can see that indeed the threshold might be you might be proposing a different threshold. Again, where's the role of the MOD in this? What's the role of the MOD in this?
I think we're, on both those questions are really they're a question about the context of consultation between the planning authority and the MOD. I mean, if we were to specify in every condition, every consultee that a planning authority should consult with, planning conditions could become very extensive. Well, obviously, it's a planning condition relating to the SDM array. Apologies if it's perhaps naivety on my part. My expectation was that a planning authority would consult with the MOD in relation to this condition.
Well, having regard to the very important international obligations which the MOD has in relation to the array, could I suggest to you that rather than hope and expectation, there should be a specific provision, if this inquiry is minded to recommend a condition of this nature, that the MOD has a role in this condition, never mind other environmental conditions, setting precedents or the like. This is the context of protecting the array.
Fair enough. If that would make the MOD comfortable that they were included specifically by reference to...
I'm not saying it is, I'm just saying in working through this condition, do you understand the concerns that the MOD might have?
I understand the specific point.
Yeah. And so far as this exceedance of the threshold, are you proposing, again this goes back to the algorithm is something different. The algorithm seeks to measure impact above the threshold, or whether it will be above the threshold. You're proposing a new threshold, so this is a new approach.
I don't think we're proposing a new threshold there. It will not result in an exceedance of 0.336 nanometers of seismic ground displacement when measured at the SMU seismological array, or such alternative maximum threshold of seismic and vibration as may be established at the time of confirmation. That's not saying that we're proposing to change it. We're just saying if that number changes, you take that number or whatever the relevant number is at the appropriate time. We're not saying that none of that condition says that we're proposing to change that number.
Well, or such alternative maximum threshold as may be established at the time of confirmation. So you are suggesting that you might come forward with an alternative maximum threshold?
No, we're just that wording to me, my interpretation of that wording is that if there is a different number at the time, you assess it against whatever the relevant number is at the time of assessment.
Yeah. Are you challenging, and this is something which I've been puzzled by your statement of case, I have to be honest, are you challenging the threshold or not?
No, this condition doesn't propose a challenge to the threshold.
So why have we got the words in parenthesis, or such alternative maximum threshold?
But just to reflect the fact that it is a parameter, as all parameters are potentially subject to change. If it was changed for whatever reason, then you should assess it against the relevant. This comes back to the source pathway receptor model. You've obviously got the source and pathway that we've discussed, that the value for the receptor is 0.336 nanometers at the present time. If that value changes, you must assess the impact against the budget for the receptor at the appropriate time. That's all that wording is intended to address.
Well, who's going to be changing? Who's going to be looking at an alternative maximum threshold?
But if it doesn't change, then the assessment is made against 0.336 and all the conditions quite clear.
All right. And you're not, as I understand your case, as you present it today, forgive me if I'm slightly confused by your statement of case and your updated statement of case, you're not inviting the reporter today to recommend alternative values for P and D, far less an alternative threshold?
Well, obviously, we provided in evidence the Heriot Watt report. The author of that report, which provides revised values for Q and V, wasn't challenged on the science yesterday. Our view, and that's corroborated by the technical experts that the applicant is called, is that the values for Q and V are 10 and 270. The scope of works just proposes to corroborate that with an additional data set.
Sorry, we may be talking at cross purposes here, and the fault would be mine if we are. But you're not inviting the reporter to say, today, she can recommend that the values of Q and V should be 10 and 2 point whatever it is, respectively.
No, we're proposing that the application be subject to the suspensive conditions set out at 4.4, which will, that is the mechanism by which the data set proposed will be calculated in the scope of work is delivered.
And just so far as the science is concerned, lest there be any doubt in your mind, Mr. Thompson, it's clear that the MOD does not accept your science. And we'll hear from Dr. Barrett on that.
We haven't heard from Dr. Barrett.
Yeah. And just so again I can be clear, and hopefully to help the reporter, just to clarify once again, you're not inviting the reporter to recommend changing Q and V in this inquiry, and you're not inviting the reporter to recommend changing the threshold at 0.336.
I think
just wish to be clear on it. And
we're proposing that the values for Q and V would be confirmed. Obviously, we have our view on the values for Q and V, and that's set out in the Heriot Watt report. That, in my view, is robust science. It wasn't challenged yesterday. I take the point that the bigger the data set, the more reliable a value is. So what we're proposing to do is to capture that data set, put those values beyond any doubt.
Yeah.
And that's what we're proposing is that this is the mechanism by which to do it in the context of the cost of the scope of work.
Right. And the threshold of 0.336, you're not saying to the reporter that should be revised?
No.
And what's described as the budget, the doubling of the threshold, you're not suggesting should be revised?
It's not in the condition, no.
So Professor Stiles' evidence to the effect that should be revised, that the budget should be revised, that's not part of your case.
Well, I think, given that Professor Stiles isn't able to give evidence today, I don't want to comment on what he would have said, but I would note that he talks about, amongst other things, the utilisation factor, which is part of the scope of work, and I have discussed in my evidence before.
Well, I was looking more at this question of doubling the threshold, and as I understand that the Professor Stiles does suggest that could be greater than doubling the budget, but I don't think that's the applicant's case.
It's not part of my evidence.
All right, not part of your evidence, but is it part of your case?
I don't think it's fair for me to say what Professor Stiles would have said. It's not part of the condition. It's not part of my evidence.
Well, again, it goes back to what is it you're saying? This goes back to what measure are we assessing, whatever the impact might be. Is it again 0.336 times 2, or is it 0.5 times 3, or what?
I think we need to be quite clear that what we're proposing is, as fully described in 4.4 of my updated inquiry report, and that is the proposal on behalf of the applicant. That suspensive condition set out in LIMS 1 and LIMS 2. Now, in there, we talked about the 0.336. There isn't a proposed, that number isn't doubled. There's no request in either of those limbs to change the number. So,
okay. You have told the inquiry about the amount of investment your company has already expended. That, of course, and I make no criticism of your company of this, but that was a commercial risk on the part of your company in the face of knowledge of the MOD's objection.
Of course, a number of commercial risks.
Yeah. And you expended that money knowing full well the MOD's position in relation to your application.
We expended that money in the knowledge of the MOD's objection to our application, but that isn't to say that the expenditure was frivolous in the context of a standing and never changing objection by the MOD, because there's two things, isn't there? There's the spending money in the face of an objection, and then there's spending money in the face of a inherent refusal by the MOD. And the expectation on our part was that we would spend the money, we'd develop the science, we'd deliver the values, there'd be a consensus and a conjoined approach to revised science, and that revised science, in our view, permits the application. That it isn't, in my view, the case that you get an objection from the MOD in relation to Estelmuir, and you just, you go into a development process wasting money because the MOD is never going to change their mind. That's not, in my view, the correct or fair approach to take to statutory applications such as these.
I wasn't for one moment suggesting that your expending money was frivolous or useless. Simply the point that you took that risk knowing that the MOD objected to your application.
Yeah, we took the risk knowing that in the first instance there was an MOD objection.
Yeah. You mentioned in your supplementary report two other applications where suspensive conditions were used. So picking up the first, that is 20 Shilling Hill, I think. And yeah, this is in 4.20 and 4.21, and the second being Little Hart Fell. 20 Shilling Hill, and you've produced the paperwork in relation to that. The context there was very different, of course, wasn't it?
What? It was a wind farm that didn't have any noise budget and got a suspensive condition.
Well, simplistically, no doubt that's correct. But 20 Shilling Hill, consent had been granted initially when it was within budget. Yeah.
Well,
then,
sorry, consent was granted for a different scheme, and an application to vary the scheme was made after Foresight had been allocated the remaining noise budget.
When consent was granted, the budget was not exceeded, for scheme A, if you wish to call it that way. They then sought to vary their consent, and they're doing so by varying their turbine height and location of those turbines after the Foresight application.
And in doing so, they required more budget.
Correct. And that being the case, the developer offered to demonstrate that there would be no additional seismic ground vibration from its proposed variation, and that it could operate within the seismic ground vibration associated with the original consented development.
I mean, there's obviously 2 points here. The first is that as a basic approach, the suspensive condition was granted, and that was granted with the blessing of the MOD. The second point to make, I guess, is that what's happened there, obviously Mr. Egan describes that it is commercial in confidence, but the MOD has actually diverted from its publicised safeguarding approach and taken an alternative approach with that applicant, which isn't set out in the algorithm. So the algorithm has not been followed with respect to that application. An alternative approach has been taken by the MOD.
Well, again, this may be a matter for legal submission, but I'll put this to you. The variation was to turbine height and location. It wasn't more turbines, and they weren't, when I say location, I mean location of the turbines rather than location of the wind farm. So it wasn't bringing it closer, if you were like measurably closer to the array. So all the developer was offering to do was to show that the original seismic ground vibration calculated by the algorithm would remain the same. It wasn't proposing recalculation of the seismic ground vibration under some other algorithm. It was simply saying, we can develop this as proposed.
I guess that should have just been a product of the algorithm, so I'm not sure, and obviously we'll hear from Mr. Egan, I'm not sure how that can be right, because if the algorithm proposes that the 20 Shilling Hill wind farm gets a budget of, let's say, 10, and and the revised proposal following the tip height increase requires a budget of 9, then that wind farm has already been allocated in that budget. So why would a suspensive condition or any kind of objection be necessary on behalf of the MOD? My understanding is that the revised application required was an increased tip height, so there would have been an increased seismic impact. And my understanding is that a suspensive condition and a legal agreement were entered into to demonstrate that through seismic monitoring, and I think this is all explained by Mr. Egan, the impact would be no greater. But it's not the same as saying it fitted within the existing budget allocation and the existing budget allocation framework. So a different approach was taken by the MOD to the generic approach that's taken to safeguarding of other wind farms.
Well, again, it's probably a matter of submission. There's no point you and I getting into an argument about it. You mentioned a legal agreement, but you earlier said that this had the blessing, i.e. the suspensive condition of the MOD. That blessing takes the form, if blessing it is, of a legal agreement, which is why I was pressing you about what role you saw for the MOD in your suspensive condition.
Yes, I think there's 2 different issues there. So the condition was applied on the planning permission, and then the legal agreement was in the context of mitigation between the applicant and the MOD. So the legal agreement wasn't like a Section 75 or an equivalent. It was a legal agreement that was entered into between the developer and the MOD. So we actually just go to the supplementary inquiry report of Mr. Egan, season 1476. So let's just run through the timings. So 421, Dumfries and Galloway Council granted consent for the variation on 23rd December 2019, subject to the following condition. So consent for the variation was granted Christmas 2019. Then 422 in February 2021, so just over a year later, the developer and the MOD entered into a legal agreement that set out the terms upon which such demonstration and verification would be undertaken, the basis upon which the developer would be permitted to operate the variation 20 Shilling wind farm, all within the seismic ground vibration associated within the original 20 Shilling wind farm. So what that tells me is that the variation was put through the algorithm. It required more budget than the algorithm had originally allocated to the wind farm. So the MOD and the developer entered into a legal agreement to control construction and operation of the development so that it did not exceed the original budget number.
Yeah, well, we're agreed on that.
But that's not the standard MOD approach, is it? It's a little bit off base.
You and I are not going to get into a discussion about what may or may not be the standard MOD approach. That's a fairly sterile and arid debate to have. Little Hartfell again was material different in that this was an application after your company's application. The MOD objected, but the planning authority, it was a Planning Act case rather than Energy, Electricity Act case, granted the permission subject to a condition. So this wasn't really anything to do with the MOD blessing or otherwise.
I think there was representation made to the planning authority by the MOD. If you, I think it's in the context of a precedent of a suspensive condition. I think it is relevant. But if I go to 4.6 of my recognition, February 2023.
4.6, did you say,
Sorry, yeah, 4.6.
of your recognition?
Yeah, 2023.
You're not saying the same thing as Mr. Regan here.
I was saying that, except that the difference is, and the MOD didn't, they haven't objected to that condition, but we're saying that ours is supported by a comprehensive scope of work. They are materially different in that ours is corroborated by a process and procedure to discharge it. This is a suspensive condition that's been imposed and not objected to by the MOD, which had no such associated proposal for mitigation.
Well, again, it's probably a sterile debate. We have the paperwork and that can make submissions on it. But whatever these suspensive conditions are, they're a long way removed from that which you're proposing, which is to carry out certain scientific research and present the findings of that to the local planning authorities to decide whether or not Fosside falls within the threshold or whatever alternative threshold may exist.
It's not so different from 20 Shilling Hill. In fact, I would say that the condition that we proposed, give me one moment. So if we go to APP 01076,
You have to let me catch up with you, Mr. Thompson. Sorry.
if we go to condition 2, which is PDF page 4 of 17,
I'm still not there. What number was that, sorry?
so it's APP 0176, and it's PDF page 4.
Who comes to you?
Have I got that right? Yeah. So heartfelt.
23rd December 2019?
Yeah.
And what page, sorry?
PDF page 4.
Oh, page 4, right, Miss Hedges.
So I thought this was 20 Shilling. You're looking at no, it's still Hart Hill.
Sorry, yeah,
sorry.
it's 20 Shilling.
20
Yeah.
shillings,
20
yeah.
shilling.
So condition 2 there, no part of any turbine hereby granted planning permission shall be erected unless and until a mitigation scheme to address the impact of the development upon the external seismic array has been submitted to and approved in writing by the Council as a planning authority in consultation with the MOD. The development shall thereafter be operated fully in accordance with the approved mitigation scheme for the duration of this permission. When I consider that against the condition that we proposed, my view is that the condition we proposed is provides more protection to the array and is more precise in terms of the work to be undertaken. The only reference there is mitigation scheme. It's not defined in any way. It's not referenced to any previously submitted document, whereas the condition that we proposed is very precise in its reference.
Well, again, it may be a sterile discussion, but here they're proposing mitigation. I've suggested to you that that mitigation is to show that the scheme can, that the development can operate in accordance with the existing parameters. We also see that the scheme is to be submitted and approved in writing by the Council in consultation with the MOD. We knew that the MOD was consulted. That mitigation scheme was drafted, now subject to the legal agreement, whereas you are proposing, I know you characterize it as mitigation, but you are proposing not mitigation. You're saying our development can operate because we say we have proved, don't yet offer the proof, have proved that the Q&V values in the algorithm are incorrect?
I think there's 2 points there. The first point is that nowhere in condition 2 do I read what the mitigation scheme for 22 Hill is to confront. It is just defined as a mitigation scheme. So on the face of it, it's not a particularly precise condition. And the second point is that the scope of works in its entirety is a mitigation scheme.
Finally, I think on the scope of works, and I just want to pick up with you in section 1. Which is headed up determination of site-specific values for Q&V.
Yeah.
What's meant by site-specific?
With the SDM your consultation yet.
All right. Okay. It's not for site. All right.
I think that's probably demonstrated by the fact that there are 4. There's a plan shown at 114 details 4 azimuths from which data is to be collected, and clearly only one of those relates to 4 sites, or the others are broadly in the direction of other accomplishments.
Thank you very much.
Mr. Thompson, I just had one question, just taking you back to, and it's whether you can answer this or have a view. It's about the utilization factor, and I think you touched on and explained that in a bit more detail as to what that actually is, and that the algorithm assumes 100% capacity from wind farms all the time, but actually in reality that's not normally the case. And so I just wanted to get your view on what do you think would be a more reasonable approach to adopt there?
I think it's obviously it is part of the scope of works to reconsider that using actual operational wind farm data. But I just want to bear with me one moment, go back to the original Styles report where this was before began. 2005 Styles report 8.
Is it 14.2? 14.
Yeah, that's it. So if we go to PDF page 84.
Question 11.
11, yeah. So what is a realistic figure for percentage utilisation of a wind farm? And this question goes on to detail the actual operational production of a series of wind farms. And it goes on at the end of the question that it's clear that in these tables and figures that production exceeds 60% capacity only about 20% of the time. And then it goes on in question 12 to say that we accept that for 20% of the time, averaged over the year, seismic amplitude levels may exceed the permitted threshold. So without an additional data set, the logical conclusion would be that 60% remains a reasonable factor. There is obviously a great deal more data in relation to onshore wind farms now than there was, so a revised value would be more robust. 6%.
And do the scope of works, does that cover that? Is that something that will be looked at as part of the work?
It does, yeah. So it was included section 2. And section 2 details exactly how that data should be captured.
Could you just run me through that, please, just so I know what the actual scope of works intends to cover?
So 2.1.1 essentially sets the background for what happened. 212 sets out how the change to the 100% or utilisation of factor of 1 occurred, and it was by reference to a METMAST, which is obviously an academic assessment of wind farm production. And then 214 onwards sets out what we're going to do in terms of data procurement. So you get publicly available production data from the selection of wind farms operating within the consultation zone. Establish the period of time that normalised production is exceeded at each wind farm, tabulate in the same way that happened in the Styles report at table 2. And then 217 plot production against percentage of time that level is exceeded per figure 66 of Styles 2005. And that will essentially give you the percentage value of the operational fleet within the contract.
And are you proposing that that figure that comes out, that approach, that percentage will then be applied universally, effectively, not just with this application, but would then be something that would sit as part of the assessment?
Correct.
Presumably, it might change as well in time and be looked at again.
Yeah. So wind farms, productivity of wind farms changes, that number should change. But 100% will never, wind farms will never be 100%.
Thank you, Mr. Thompson. Mr. Hardy, do you have any further questions?
I've just got 2 points, and one of those picks up really on that utilisation point. Now, Professor Stiles was going to deal with this in detail, but you do touch on it. So just following on from that question, I wonder whether you could pick up Professor Stiles's supplementary inquiry report. So that's APP 01085. And so utilisation factor is dealt with by Professor Stiles in his section 5, and the part that we've just been taken to in the Stiles report is replicated here in paragraph 5.9. You can see that's an extract from the 2005 report. You've got that question and answer. You've got that whole question. I'm interested in 514 over the page.
Yeah.
And in terms of the work that Xi are doing, so the postulated utilisation factor of 100% would mean the predicted turbine vibration levels from the physics-based approach will always be assumed to generate ground vibrations which will propagate from the sundry wind farm locations to the array, as if all these turbines are operating at full rated power 100% of the time. That's illogical, according to Professor Stiles, come to the view, given the data that was examined in 2005. What's your understanding of that position in relation to the TASIC or the what was accepted by the MOD and the CBTA?
Obviously, the STARS report in 2005, and including the utilisation factor of 60% and a 20% exceedance, was reported and approved by the CTBTO. So the fact that that has been removed from the algorithm, in my view, is rowing back upon the lessons given by the CTBTO to that express acknowledgement.
Madam Reporter, I'm sorry to interrupt, and it's the manner in which the question has arisen, and also the circumstance we find ourselves in. Professor Stiles has stated that the CTBTO approved the UK government's approach and the algorithm. That is not accurate so far as the MOD is concerned, and we have the paperwork to show that there was presentation, indeed by Professor Stiles, to the CTBTO, but we don't have a document saying the CTBTO effectively signed off and approved that. It's maybe a matter of detail, but it's not accepting part of the MOD that the CTBTO approved, whatever is meant by that word, Professor Stiles' work and the algorithm which was produced in consequence of that. and had Professor Stiles provided evidence, I would have crossed him on that point. And I suppose it's really, that would flag up any questions which are asked in re-examination of this witness under reference to Professor Stiles' report. They have to be caveated with the effect that this is untested evidence.
That's perfectly fair. We're dealing with circumstances that are difficult. That is what Professor Stiles had to say. If the MOD want to challenge that, then they can do that in writing. The second point, in the scope of works, if we could go to section 3. And you recall you were asked questions about potential revisions to the source term. Do you recall that? Professor Stiles deals with this as well, but it'd be the same point about that's in writing. MOD can make its views. No, but 3.2.7. What's your understanding of that, and whether or not any consequential revision to the source term would be taken into account or not?
So this is 327 is the line that specifically addresses the point about the use of the values of Q and V in the source term. So it expressly addresses the point that was raised in the examination.
So is it a problem or not?
No.
That's all I want to ask in re-examination. Thank you very much, Mr. Thompson.
Thank you, Mr. Thompson. Okay, I propose that we finish for today, and we meet again tomorrow morning at 9:30, where we will commence with the Ministry of Defence's evidence. Thank you. I'll see you all tomorrow.